and welcome everyone. This is the panel on privacy-preserving advertising. Just to make a very quick introduction to the topic, as probably most of you know, the internet of today is built on advertising. The big five companies all run ads to some extent. Google and Facebook, for them, it's their main business. At the same time, it is widely perceived that the status quo in terms of data protection is untenable. Data protection authorities are probing the ads tech ecosystem, how it can be reconciled with GDPR. There's even a competition angle to it. There was a panel on that yesterday. So, and at the same time, we're looking at the phase out of the third-party cookie as something that could or might happen next year. And then we will quite likely enter a new phase of online advertising, one where hopefully privacy protection is a bigger issue. Having said this, we can go straight into an excellent panel with some very knowledgeable people on the subject. Just to introduce myself, just very briefly, I'm Alexander Fanta. I am a journalist with Netzpolitik.org in Germany, a website focused on digital rights news, and I'm also co-author of a study called Google the Media Patron on how Google is strategically funding publishers and interacts with them. I'm hoping that the panelists will introduce themselves, so maybe we can just go,
Hi, I'm Udbhav Tiwari. I work with the Global Public Policy team at the Mozilla Corporation.
My name's Catherine Armitage, and I work at AWO. We're an agency focusing on digital policy, data governance, and litigation in the data rights space.
My name is Karolina Iwańska, and I work at Panoptykon Foundation, which is a Warsaw-based digital rights NGO, member of EDRI, European Digital Rights, and we've been doing a lot of advocacy and litigation work around online advertising for the last couple of years.
I'm Chris McKim, and I work for DigiConnect on digital privacy and cloud security. I can't actually see anything apart from my black screen, but you can hear me, team.
So I would like to start with Karolina, and I have some questions written down that I can no longer read. To go briefly into this, Karolina, civil society has scored some crucial victories in the quest to rein in ad tech over the last couple of years. Do you think that these are have been a collaborative effort of civil society, or are there some outstanding kind of people in this? And what can be done to improve kind of the knowledge sharing and strategizing, especially beyond the EU, on the ad tech ecosystem?
It's true that there has been a lot of development in the last year, basically, or 2 years, when it comes to regulating or limiting the harms related to online advertising. And on this and other conferences, we've talked a lot about what those harms are, so I'm not going to repeat that. But before I also answer your question, I wanted to emphasize a few points of what our perspective is about what actually privacy-preserving advertising is and what it is not, and what actually we've been, as civil society, as digital rights organizations, fighting against and for. If I were to distill what for us the essence of the problem with behavioral advertising is, I would say that the original sin of this model is constant behavioral observation of every step that a person makes online, which is then used to make predictions about him or her, inferring things that they haven't explicitly and consciously revealed for that purpose, and which often exploit their vulnerabilities that they would not like to be used for advertising. Neither ads of new shoes or especially not for ads for loans or a political party. And in my opinion, this is the case for both open web advertising that is sold through real-time bidding and for advertising displayed in the closed ecosystems of online platforms. The difference between the two being that in real-time bidding, in addition, we are dealing with the massive data leaks, broadcasting and sharing of data with hundreds of intermediaries. And in fact, our fight against that model has been also a fight in terms of narrative, right? Because the industry often argues that people have full control and choice over what is happening to their data. And sadly, especially during the DSA debates last year, we've seen a lot of policymakers buying into this sort of narrative and emphasizing the meaning of consent. But as we've seen, and actually has been confirmed by the Belgian Data Protection Authority in the case against IAB Europe that focused on transparency and consent framework for real-time bidding, these controls and choices are just an illusion. In fact, they don't really exist. Because first of all, on the open web, people are bombarded with consent spam that is not only a nuisance but also weakens this warning effect or alert effect that people should have when they are requested for consent. Not only that, often these consent boxes are designed in a way that uses dark patterns and manipulates people into making choices that otherwise they wouldn't have made. And we've seen that, for instance, when Apple introduced some fairer consent boxes that clearly said, I agree and I don't agree, 80% of the people didn't agree, which is not the case for consent boxes that exploit these manipulative patterns. And at the same time, there is also a limit to what people can actually agree to. If they cannot reasonably predict what's going to happen to their data, which is the case, I would argue, both for real-time bidding that has been actually confirmed in the Belgian DPA decision, that the data is shared with so many companies, third parties, that actually you cannot know what is going to be used for, what purpose is going to be used for, what's going to be inferred from that data, and there's no possibility to control that. But I would argue that it's also the case for platform-based advertising, where the depth and the scale of profiling and the depth of assumptions that are made about people based on the data collected is also very difficult to predict, to understand what is happening to that data and to fully control it. So I've mentioned a couple of fights, and indeed we've seen some successes. I think it was a collective effort with a couple of leaders of that movement. So I've mentioned already the case against transparency and consent framework in Belgium that was coordinated by Johnny Ryan from the Irish Council for Civil Liberties, but with participation from a number of organizations that have filed complaints in local jurisdictions that were then transferred to Belgium under the one-stop shop mechanism. And we've seen big success with that case. Basically, at this point, we have received a very good decision that basically outlaws transparency and consent framework. And right now we are in the appeal process because the IAB appealed that decision, and IAB is supposed to present like a repair plan to bring a TCF back to compliance. And I really don't know how they would do that, because the faults that the DPA found were so fundamental that I don't really see how it would work without redesigning the entire system. So that's the one fight. And the second fight, a more recent one, I mean, they're mostly happening at the same time, so it's a parallel. The Digital Services Act, which I would not categorize as a huge success, unfortunately, because what we ended up with is a pretty narrow prohibition of profiling based on sensitive data, which I'm quite skeptical, maybe wrongly, maybe my colleagues on the panel or the audience will not agree with me, but I think that it will not change much when it comes to actual practices, but I think it opens a way for potential litigation and trying to perhaps expand this. And there was a huge coalition of organizations led by EDRI, by People versus Big Tech Coalition that until the last minute was really fighting during the trialogue as well. You know, there are so many turns in the last minute that I think was a collective effort, a huge one, because we had a huge opponent on the other side. So I think that even the fact that we got something that we managed to bring this into the mainstream debate, I think that was a huge success. Although, what's going to happen, I think that remains to be seen.
Thank you also for these preliminary remarks. Catherine, just passing on the topic to you. What are your thoughts on this, and what would you say? How is your kind of perspective on the transparency in ad markets? And yeah, can you? Thank you.
Yeah, I think that it's interesting to hear what you're saying, Carolina, about with the content of exactly what's in the DSA. But I think what the DSA was really good at was creating a really public and vibrant debate about this issue in a slightly different context to places where it's previously taken place. I think that the notion of privacy-preserving advertising that we're here to talk about today is, I think it's slightly a bit of a misnomer. I think the notion that we can put this label on some types of digital advertising and it will be better is something we should be a little bit wary of, because the harms related to digital advertising, as Carolina said, it's not just about privacy. There are so many other harms related to advertising that go much further about, I don't know, the environment, the ability to perpetuate discrimination, stereotypes, security risks, impact on journalism and democracy. I mean, I could go on and on and on, but I think everyone in this room knows that this is a much, much broader debate than just privacy. And in a way, having that debate within the context of the Digital Services Act, which is a piece of legislation designed to tackle much more than just this very narrow angle of privacy, meant that at least that debate was happening in a context in which we could talk about the kind of the broader impact of the business models and the kind of the current digital advertising systems. And I think that it was just probably the starting point, as Carolina's pointed out, actually what's ended up in the final text. There's a debate over whether that would actually make any kind of substantive difference to the current system that we have today, but at least it's kind of made the point within the kind of the legislative sphere and the policy debate that we need to be thinking about this from a much broader perspective. And potentially also there's a narrative to say that maybe the DSA wasn't the right place to have that debate because there just simply wasn't enough space to get into it with the level of detail and the nuance that's necessary to really tackle a system which, as Carolina pointed out, is incredibly complex. I think many people who work in the industry and make a lot of money out of that system themselves don't really understand how it works and what harms it is having and also how to fix it. And therefore, I think it will be great to see if that debate will have a kind of long-term impact in terms of enabling us to have an ongoing discussion. Let's talk about the bits that didn't end up in the DSA text. Where are they going to be now? Let's talk about the future of different pieces of regulation. And that's actually something that I'm working on at AWO. I'm doing my focus at AWO is working on research related to policy and tackling some of the issues and harms related to digital advertising from a policy perspective. And at the moment, I'm writing a study for the European Commission about recent developments in ad tech and the impact on advertisers and publishers. And it will be interesting to see how some of the topics that we're looking at in that study can contribute to that sort of hopefully ongoing debate about, what do we do about digital advertising?
I think there was a lot to react to for Christian, especially in terms of the larger looming question of how sustainable is the current ad tech ecosystem. So, Christian, will you go into it?
Thanks, Alex. Thanks.
Thank you. So going to our last panelist, from what we've heard, you could assume that AdTech ecosystem is in a pretty bad shape, omni-shambles, one might say. But the industry players, the major ones, Google and Apple, have already proposed solutions. So how do you, what's your perspective on this in general as an industry player, which is, I think, an important perspective here, and especially how do you judge the Google Privacy Sandbox and Apple's proposals in this light?
Thanks. I mean, I think that it's very important to ask a certain set of questions before evaluating these technical proposals. The first is, who do they stand to primarily benefit? The second is, to what extent will they fix the outcomes of behavioral advertising and how harmful they can be? And finally, in what manner are they being developed, and what avenues are available for people to be able to both understand and contest the assertions that these proposals make? And at least at Mozilla, our experience has been that so far, a lot of the standards, and these are sort of like the technical parts of privacy-preserving advertising, are largely taking place in silos inside these large technology companies with very little transparency on how they're going to be built, the manner in which they're being tested, and the sort of impact that they're really having in the world at large. There are lots of conversations taking place between other advertisers, ad tech companies, and some of these larger platforms, but very little with other stakeholders in the ecosystem. So one of the things that Mozilla has really been pushing for is to make sure that these standards, while it's okay for them to germinate within these companies, when they start being developed, need to be developed at open standards organizations like the IETF, like the W3C, because unless that takes place, it's very, very hard to say that they will solve the problem of third-party cookies or of other forms of tracking. And even if they do end up solving some of those problems, and it's definitely, I think we're at the stage where it's still very much an assertion, we think that there are some sort of more inherent issues that only laws and regulations can solve and aren't for technology to solve. So just to give you an example, if all of the proposals that were made under, say, either the Privacy Sandbox were to be absolutely true in the claims that they make and were to be implemented successfully, all it would really do in practice is, while curtailing the practices of many other players in the ecosystem, create another walled garden around large technology platforms using the first-party data sets that they already have. Because if you're an advertiser and you have hypothetically 100 euros to spend, you would spend those 100 euros right now as an advertiser in the place where you could be given evidence that it's been targeted most effectively. And the information that is present within these first-party data silos is so vast and expansive, spread across so many products and services, that it's only these small platforms that can make those claims and assertions. And you could see that when Apple came out with its app tracking transparency framework, I'm just using examples, but if you took a sliding scale of like Snapchat, Facebook, and Google, and the amount it impacted Snapchat, the amount it impacted Facebook, and the amount it impacted Google were all very different, primarily because of the different categories of first-party data stores that they already have. And we think that laws and regulations have to play a very important role in breaking those silos, right? So the DMA has made some progress on that front, where there are parts of the DMA that talk about intra-company data sharing. So if you're a platform that operates, say, 10 services and you collect data from those 10 services, combining it to create more holistic profiles of your users is something that we think the DMA is not going to prohibit, but certainly make much harder than it is right now, depending on how it's implemented. And we definitely need far more concentrated efforts in that direction that make sure that, like I think Christian mentioned, that it's astroturfing, not just to say that it's hiding the intent behind the proposals, but it's astroturfing because, in fact, it increases the power and influence that these platforms can hold if it goes in the direction that it is going right now. So because of that, as much as technology proposals are important to improve some of those privacy aspects, it's equally important to make sure that the larger platforms and the data hosts that they already have are also more either more at a minimum more transparent, but also that they can do much lesser with it for the harm that they are clearly causing in society.
So one thing in particular I wondered about, namely that I think we can kind of see from a lot of the input we got now that it's a very opaque system, and it's very complicated as an outsider to understand what is actually going on, even though we must assume that it doesn't really serve, we don't have the feeling it serves the business customers of the ad tech ecosystem or the people whose privacy is affected. But at the same time, the question, Catherine, with the study you mentioned you're working on, is do we know enough about the way the system works to effectively regulate it?
That's a really good question. I think that, as Christian said, there are things, like for example in the DSA around transparency, that are probably going to help in this regard. But I think the short answer is we need more information from the companies that are making the biggest profits from this system today in order to make really good judgments. This is definitely something which I think you can sense when you read decisions or cases written by competition regulators, that it is difficult to get information. It's difficult to get basic information about who is making the most profit from this system. Even, to what extent are, country by country, who are the biggest recipients of advertising spend on a kind of company level. This information is not available. Any information that is available is stuff that is printed in those companies' annual reports, usually at a very high level. And that's just one example, but we're lacking, beyond that, obviously, a lot of technical information that would be helpful. I think that there are different ways that you can do this. I do think that one thing is also, there are many people who have spent time working in and around the advertising industry who may be interested in actually contributing to solving some of the problems, particularly when you get beyond a certain management level. I myself spent about 10 years working in the advertising industry, first at Procter & Gamble, which is the biggest advertiser in the world, and then at the trade association that represents advertisers, the World Federation of Advertisers. I'm not sure that gives me any particular insight at a certain level, but it does help. I think sometimes when thinking about these issues now from a policy perspective, it gives you an understanding of some of the incentives that are ingrained in the industry that are preventing change. I think actually when you talk to people who work within the industry, I know best from the advertiser and publisher side, but I think it's the same with sort of intermediary ad tech world. People will tell you that they are also concerned about all the same things that we are concerned about. They are concerned about the impact on privacy and the broader harms. They're concerned about the lack of control over data within that ecosystem. On a personal level, this is something that people care about, and I think there was a survey that was done not so long ago with SMEs, advertisers and publishers, that said that, people, are you concerned that you are, infringing people's privacy and their fundamental rights? Obviously, everyone's going to say, yeah, of course we're concerned about this. But actually, there are many of those people who just don't actually realize, even from the inside, what a negative impact this is having on society. And I think that that's something which we could have if we could have a much more open debate with some of those people. Maybe it's behind closed doors. Maybe it's in a way that means that they would not fear some kind of retribution for speaking out against their company. I think that would really help, because I think actually within the industry there are some very well-meaning people who have a lot of insight that could really contribute to this debate. But right now I'm not sure that they're necessarily involved in the discussions, or they don't understand how they could get involved in these discussions unless it's with their industry hat on, which completely changes the way that you can participate in those discussions, and I can tell you that from experience. So the short answer to your question is I think there is a lack of information. How we get there, I think maybe there's not a clear answer, but there's just a few of my thoughts on it anyway. Super, many thanks. I will pass this on to Christian actually, and maybe you can give us some insight into, we have a very complex landscape where data protection enforcement is with national regulators, the EDPB, then the DSA creates some new regulatory opportunities, I'd say, for the Commission. And then there's an ongoing ad tech probes by the competition authorities against the Commission. So how do all these kind of different regulatory perspectives work together? Is there already effective cooperation, for instance, between competition data protection authorities, and how can they kind of get this input from the industry, from other industry players? What's your thought on this?
Yeah, I think that's the question. example, I can identify the appropriate database system to use in the future and allow for, as you see, going through the course planning the consent framework, something like that. So there's lots of good stuff to the specific parts that the document here, the tools, the quotes, some other things to see. You mentioned about the competition and consolidation system. Competition looks not as I interested in structure of the market and the way there seems to be the approach seems to be emulating many advertisers practices that to be companies what they call the QR Facebook in particular with the thousands of the share.
Thanks. It's one could say a regulatory Rubik's cube, and as Christian said, there is no single director general just for the ad tech industry. But I guess the question that would come from this is how. So Carolina, maybe you can give your opinion on this. So how could an effective regulatory framework look like? Is it, what can, for instance, standards bodies contribute, but maybe also is there a need for maybe a single ad tech law by the European Union?
Yeah, I would say that's a good idea, and I think that a good regulation on advertising should not be prescriptive as to what business models companies should use, but rather should specify what is not acceptable, and to outlaw certain worst practices, which for me are constant behavioral observation and inferring personal data about people. Not so much even, I could definitely imagine, I would make a distinction between personalized advertising and behavioral advertising. I think that during the DSA that those terms were kind of combined in the narrative in the big tech lobbying. Also, targeted advertising was, presented as like the only option, while contextual advertising is also targeted. It's just not targeted to based on personal data of the person, but rather the content of the website. And I could definitely imagine, personalized advertising that is privacy preserving in a way that it gives people the agency to proactively define categories that, for instance, they would be interested in, while at the same time not putting the burden on them. So I could imagine the architecture of a privacy-preserving advertising system, which by default protects people from intrusion into their privacy, but at the same time, if they want to, they could, set, for instance, specific, not give this blanket consent that we are dealing with now, where you just like consent once with one click through a cookie notice that is designed in a way that there's a huge green button, I agree, and then 5 layers later you can switch off 400 trusted partners. But so I could imagine a fair system where people could actually proactively specify what they are interested in, and they would define that, not companies that would pretend that they know better, that could infer information about them. And I see also very interesting developments happening also in terms of we touched briefly on the recent technological developments on Google's privacy sandbox, and I share Ubav's concerns that it actually, what it aims to do is not really to limit the core of the problem, which is the amount of data and the uncontrollable inferring of data that is happening, but rather who does the inferring and the number of actors. And I agree, 100% that it doesn't mean that the harms are not there. But there are also positive developments, for instance, with exactly trying to take this burden off users and automating the communication of their preferences, for instance. So yesterday, I believe there was a session on the advanced data protection control, the kind of new and improved do not track that is co-developed by NOIP. But the problem is that the do not track failed because it was not enforceable, right? Companies were not obliged to respect the signal that your browser was sending, the default. And I would say that I would love to see a GDPR case on whether that is a violation of principle of privacy by design, for instance, if companies do not respect this sort of signal. But I think that we could have in the privacy, particularly, I think there was also an effort to include that in the DSA. I think it was a failed effort eventually in the trialogues. It failed to actually force companies, to oblige companies to respect this sort of automated communication of people's preferences that would take the burden of making 100% impossible, 100 impossible choices per day that that are not even a choice because you're not even aware of the consequences of giving consent. So I think the right regulation should build incentives for strong default protections, but also, not prescriptively say what the company should be doing. Keep that open, but create obligations on respecting, for instance, the automated communication of, refusal of consent or the possibility to use only a specific type of data, and so on.
Then, of course, the do not track was a provision envisaged by the Parliament for the e-privacy regulation, which was proposed some years ago and still hasn't come about. It's basically stalled. Would like to ask Christian about that in a bit, but first, I want to go back to Udaf and ask you, how does Mozilla as an industry player feel about that? How is how could a fair deal with the users, privacy preserving way to do advertising look like? And where do you see the regulatory landscape? How could it encourage that over the next 5-6 years?
Sure. I think that of the different things that I could say, the first that I would say is that at least what's taking place right now is that even within how regulators are viewing the ad tech sector, there's this impression that there are these large big technology companies and they just want to keep doing advertising the way that they do and add a veneer of it being privacy respecting, and therefore let's investigate it very strongly. But what's happening underneath the waves is actually a little more nefarious, right? Because at least in our experience, we think that existing ad tech players outside of the big technology companies are actually using that momentum as a Trojan horse to prevent a lot of the privacy protecting practices that are being developed technically. So if you look at what happened with the Competition Markets Authority's voluntary commitments for the Google Privacy Sandbox, a part of those commitments include explicit commitments that third-party cookies will not be deprecated for 180 days, and there will be a standstill period that says for these 180 days, we're not going to do anything. We'll give you an opportunity to tell us what to do, and by extension, give opportunities to other advertisers to tell the CMA what to do as well. So what you have here is if you remove Chrome, what you have, third-party cookies are broadly now restricted across the ecosystem, right? Whether it's Firefox, whether it's Safari, browsers like Brave, but also otherwise. Chrome is now the only biggest player that does not restrict access to third-party cookies by default. And you have a regulator that's now said you can't remove third-party cookies for 180 days, and we will look into whether you can, and only then you can do it. And the reason that's been done is because it's been posited as a competition concern. It said that if you do remove those third-party cookies, you end up creating a scenario where other advertisers simply will not be able to operate, and competition is a good thing, right? But I think that this is a textbook example of why competition regulators and data protection regulators working very closely together is probably the first thing that needs to happen in the ad tech space, because because of how consolidated the ecosystem is, every single step will have implications on both of those outcomes, and like leaning too far in the direction of one is going to end up very tangibly harming the other. And that's broadly been Mozilla's assertion as well. Like we've said a lot of almost everything that I'm saying now is something that we've been like saying publicly to regulators for quite some time now. And that is that like it's a false binary between competition and privacy that like different interests try to keep positing in a particular way. And it's very important to break through that and create effective regulation. In the medium term, we think that policy and technology will actually have to arguably go hand in hand in a way that I don't think they've had to go hand in hand, at least for any other sort of regulatory aspect of the sector so far. And that's because they're so intrinsically linked in the space that if there are new like standards being created that say allow certain aspects to take place, but without the implications of, on privacy and discrimination and a bunch of other harms, because technology can only go so far, law needs to create the outcomes or the incentives that force technology players to develop and create technologies that lead to a better sort of scenario. And whether it's a dedicated legislation, whether it's enforcement of existing regulations being better, whether it's far more research on a sort of public in a public level, so not just very dense papers, but make ad tech as a thing much easier to understand than it is right now, are all different paths, I think, to that ultimate outcome. But we definitely think this is like a medium term play. It's very hard to see in 2 years from now any of these problems being meaningfully solved, because both they're very hard, but they also require the level of cooperation between stakeholders that is, at least so far, has just begun to start happening in the tech sector.
Great. So I will very quickly have a question for Christian, and then I would like to start taking some questions from the audience. So those who want to ask a question, you can start lining up behind that mic. So the one thing I wanted to, Christian, what are you saying in terms of what is the regulatory environment that AdTech can expect over the next couple of years? Is there anything coming from the European Union, from the Commission, in terms of new regulation? And do you think that the e-privacy regulation will ever be finished? Thanks. Yeah. So, yeah, publishers, I think it bears to mention, are an important driver of regulation that because they're feeling that they're getting pinched by the ad tech system. But let's take some questions from the audience. Please identify yourself and also please say who you want to answer the question.
Hello. My name is Lexo Zardiashvili. I'm from University of Leiden, and first of all, I would like to respond very shortly to all of the panelists and some of the points that were raised, and then I want to ask two questions, one for all of the panelists and the second one to Mr. Tivari. Catherine was saying, I think it was her, she was saying that there is lack of transparency or clarity somehow what these components are exactly doing when it comes to the processes of advertising, as well as where the money goes and etc. So, but just before that, Christian was mentioning, for example, the British study by the CMA, and I think if we read just that document or a lot of the articles from academics, such as the person who is standing right behind me, it's quite clear what are they doing or where the money is going. At least for me, it is, and also. There are hundreds of patents, right, filed by Google explaining how exactly the behavioral targeting is working in different contexts. So, just to give the brief summary of what's going on is to the extraction of data as much as possible, as further in the internet as possible, with the only objective to earn as much money as possible to these actors, and just to be clear with that, with as much influence on the individuals as possible as well. And my two questions would be then, the first one, why since 2001 or 2003 this behavioral advertising has been running and we all see this happening, and why we haven't prohibited this practice so far? That's the one question to all the panelists. And the second question would be, how do we monetize the internet without this business model? And this question maybe first of all will go to Mr. Tivari. Thank you.
Take maybe, Catherine, could you try to address the first question? Why has nobody stopped this business model?
Yeah, I think there's two things here. I think the first thing is, within the industry, obviously, there is an enormous pushback. They have enormous amount of resources to push back against proposals which could have a significant impact on their business model. I think just thinking about the incentives that the industry have, you at a corporate level, many companies in the entire ecosystem, from the advertiser right through to the publisher, they have an obligation, they have a legal obligation to make money for their shareholders. And they are all terrified that if something changes in this current system, they will make less money, right? You can think about that from big tech, but also from the perspective of a publisher. They're terrified that if they change the type of advertising that they sell to advertisers, if they don't know if less advertisers buy their advertising and want to stick with the current model that other publishers are selling, they could lose money. Similarly, from an advertiser perspective, despite, as Christian pointed out, the lack of independent studies on effectiveness, most of the advertisers pouring money into the system believe that this is the only and most effective way of doing digital advertising. And they are all quite terrified that if they change that, their advertising could be less effective, which means they have less successful advertising campaigns, and effectively that could impact their bottom line. We're seeing a bit of that in reaction to the early days of Google's announcement that they were going to deprecate third-party cookies, but it's definitely a kind of existential fear that you get. There's also like a level below that corporate level, which is about just the way that the advertising industry chases KPIs. So the things that get people's bonuses paid and ensure that they get a good review so they can keep their job next year. These are all, in the marketing industry, these are all things like how many people clicked on your ad, how many people viewed your ad. Actually, there's a lot of debate as to how accurate those elements of measurement are. But at the same time, these are literally what people are putting in their performance reviews at the end of the year if you're working in the marketing industry. And therefore, again, taking any action that could disrupt that is very scary for a lot of people. The changes that Apple made to the app tracking transparency did lead to some advertisers and some app developers feeling like there was a period where they had less access to data about how many people were downloading the app or clicking on it, for example. And that actually led lots of people to have kind of very late nights, working late, scrambling because they had to write a report for management about what was happening. And so these are all the kind of incentives that sometimes we forget about when we think about, well, there's a piece of regulation that says this, why can't we just move forward with it? But these are all things that are just are pushing the industry to push back against this. And I think, back to my earlier point, it would be great if we could think of ways to try and change those incentives, maybe through regulation, so that actually we can change a bit of the narrative that's taking place there. I think the other thing is that, no, actually, I'm going to stop.
Can I add one point as well?
Sure, yeah, absolutely.
So I also wanted to emphasize the narrative battle that is going on, right? During the DSA debates, we've all seen the aggressive lobbying of Facebook using SMEs as, oh my God, if we ban behavioral advertising, then SMEs will not be able to reach people and make money after COVID and so on. And it was really fascinating and frustrating to see how uncritically policymakers at the very highest level of the EU accepted this narrative without, questioning it even. And I think, and it's not to be underestimated. I think when we have this narrative going on, when there is no other sustainable way to fund this, maybe goes to the second question as well, to fund the internet, then we adopt laws that do not create the right incentives. We don't enforce them because we are afraid that publishers will now have it even worse than they have already. And because when we don't do that, there are no regulatory incentives and financial incentives to invest in alternatives that would actually produce this evidence that you can do advertising differently. So for me, it's a vicious circle that has to be broken at some point.
Sorry, I just want to really quickly comment on this as well. CPDP has been running for 10 years now, no? And we've been probably 10 years ago, it was the same things asked, and the SME argument was the same argument that Facebook was posing. And Facebook and Google are the companies who are sponsoring this event, and probably a lot of the research that has been happening here. And then their revenues, and 90% of their revenues coming from this practice. So I think when you're saying at some point we have to break it, when is that point? If DSA and DMA don't do anything, GDPR doesn't do anything, AI Act doesn't do anything, then when?
Do you want to react to that?
Sure. I can answer the second question and then react to that very quickly. In terms of what is the future business model of the web, I think it's useful to look into why does targeting or tracking take place on the internet. And a lot of the examples, for example, that were just used on the panel about how many people clicked, how many people viewed, whether they went ahead and bought the product, are all actually the primary justifying factors behind why tracking takes place in the way that it does on the web. And there's definitely a fair bit of work happening on technical fronts that I think can lead to things like attribution, lead to things like follow through without having to carry out tracking in the way that it is done right now. So the short answer is I don't think the future of the web is a web in which advertising does not take place. It's a future of the web in which advertising takes place without a lot of the tracking that happens right now. And it's just become so pervasive that it's very hard to imagine a future in which that can happen. But there is a lot of research and work taking place in order to create that like outcome. But ultimately, like just to reiterate the point, that doesn't mean that technology will fix it. Laws and regulations need to be there to prevent some of the worst things from taking place, while technology keeps making things a little better, right? Like, so it's everyone is playing different instruments, but like the symphony that needs to happen at the end of it really needs to, like, I think, come together in a way that hasn't really started happening so far.
Thanks. So I will take the next question from the audience. Please try to keep it not too long.
Yeah, Michael Veal from UCL. My question is around privacy or confidentiality preserving ad blocking in the future. So we've got acts like the DMA, and we seem to indicate that we would like people to have more control over their devices, and many people in the room, I think, like the web as a result of that. But should and most privacy-preserving advertising protocols require people to do things on their device, require their devices to participate in this protocol. Should people have an option to turn this off on their device and to stop this functioning? If they don't have an option to turn this off, how is it enforced? Is it enforced through hardware and operating system controls? Is it enforced by checks whether you're advertising properly on yourself, zero-knowledge proofs or similar, trust tokens were in the privacy sandbox? And how would that function as a result of that? And so the kind of cookie wall debate may be coming back, and how does privacy-preserving advertising interact with autonomy over devices in our pockets?
Who would you throw this question to?
Oh, sorry. Ubdav and maybe Christian as well.
So we think that, at least at Mozilla, we think that users should always have a choice, and we think that in the similar way to which you can install an ad blocker on your browser right now on Firefox is the extension of that ability to exist on mobile phones should exist. We, for example, are one of the only real browsers that is available on Android that lets you install extensions, including ad blockers, to like bring that functionality that exists in more open spaces like the desktop space. And in practice, at least, the way that things like with the privacy sandbox, the origin trials and things like that have been taking place, these are features that you can enable and disable. So I think it's definitely on both civil society and generally digital rights organizations to make sure that that autonomy aspect is present in any regulatory debates that take place, because there certainly have been moves historically, not just recently, to prevent, to take the lessons that large technology platforms have learned from having slightly more open models in, the desktop operating space and computers essentially, and prevent those features from being available on closed devices and operating systems, and making sure that it's pretty clear that they can't create an alternative and then force that alternative upon users and not give them the choice to turn it on and off is definitely something that I think both pressure at the time of development, but then laws and regulations after they've been passed in order to make sure it stays that way will be pretty crucial.
Christian, do you want to do a very quick reaction, Christian?
Well, I think that technology definitely have a role to play, but I personal view, but I always go back to the I think made by Carolina, that it shouldn't be on the individual to have to, whatever tools they have in order to protect themselves. There should be certain behaviours that are just off limits as unethical. And unfortunately, there are, coming back to the question, there are people. If there's money in the game, then people always find a way of doing what they want to do and getting lawyers to justify it. And then it becomes a question for courts and enforcement. That's why I think we have to have much more visibility of what's actually going on in the ecosystem in order for it to be.
I would go to the next question from the audience.
Yep. Dennis Holmes, Meta, and this question is for Carolina. You outlined a regulatory framework that you felt like would be a way in which we could have privacy-preserving advertising, and you also made a comment that we should not be placing the burden on the user to make choices to protect themselves. So my question for you is, in that new framework, where do you see consent fitting in, if at all, and how do you sort of imagine user control in that sort of new framework?
I think it's a UX design question. I think that when the default is set on no tracking, no data, and if the browser communicates this sort of default, this should be respected. But at the same time, I could imagine, if we're talking specifically about Facebook, for instance, I could imagine a place in the settings where people could actively go to without being nudged about it to set some sort of settings, and for me that would constitute consent, right? Because you proactively do that. But I wouldn't go for, you know, a super broad blanket consent, but rather, you know, proactively defining the sort of types of, you know, topics of ads, for instance, that people would be interested in. At this point, like, you know, you could argue that there is a, you know, a control panel on Facebook, but actually it's very inefficient. Panopticon ran this experiment that we dubbed algorithms of trauma, where we had a user, a Facebook user, who was seeing a lot of ads about fundraisers for terminally ill children. She's a mother of a child herself and is very anxious about health in general, due to also having lost a parent to cancer recently. And, you know, when she wanted to get rid of those ads, she went to Facebook settings and deleted all the kind of categories related to health that were attributed to her, right? Because on Facebook you can see all the different interests that Facebook attributes to the person. And so she deleted all health-related ones, like, you know, hospice, cancer, that sort of interests that were attributed to her by Facebook based on her browsing patterns. And even though she did that, the experience has not changed. She you know, at the beginning, the number of ads about health dropped, but then it increased back to the original level because of how Facebook actually targets those ads, right? We talk a lot about advertisers, but you know, advertisers actually select the audience, but who is going to be in this audience is up to the algorithms of Facebook that, you know, optimize the delivery of the ad to the person who is most likely to react to this ad. And maybe also connecting what Christian was earlier saying about sensitive data and the DSA as well, prohibition of sensitive data. Why is it not working? Well, the reason is that the algorithms that do the optimization, the algorithms that profile and target people, they do not operate on like human-defined categories of, you know, I'm lesbian, I'm gay, I'm something. That these are correlations that, you know, are produced in real time. They are not put in some sort of central database where the user can look them up. It doesn't work like this. So that's why I'm skeptical about this prohibition in the DSA and about GDPR enforcement of sensitive data. And we've tried to use also the control tools that Facebook offers, and it turns out to be not efficient. And there's no single switch of button where I could say I don't want any personal data to be used. In fact, Facebook, I don't believe, even asks for consent. Right? There's a case in the Court of Justice of the EU where behavioral advertising is considered part of the service. So when you sign up to Facebook, you sign up for a personalized ad service apart from the social network. So at this point, like talking even about consent is kind of pointless because Facebook does not use consent at all in the first place at the moment.
So what do we do?
Well, we'd wait for what the court says. I expect that the decision will be that, you know, this is absolutely nuts to think that advertising is part of the service. And then hopefully when we also have in the DSA that very, again, limited in the trialogue dark patterns prohibition, and it remains to be seen how effective it is because it says it cannot interfere with the GDPR and like I don't know how it's going to be interpreted. But hopefully these sort of defaults are going to make it easier for people to actually express in an effective way what they actually want and not have, you know, have the burden to go someplace and to switch off the different settings that might actually not work eventually.
Okay, thanks.
5 minutes left.
So I would like to, I think there's two more people who want to ask a question. So maybe you could take both sequentially, and then we can see if we can get them answered just before lunch.
My name's Nicholas Wallace. I'm a reporter at MLEX. The panel's already floated the idea of a comprehensive regulation on digital advertising. Mr. De Cunha said that he believed that more comprehensive regulation may be needed even after the privacy regulation passes, assuming it does. My question is, assuming the EPR passes, what would be left for the Commission to propose on behavioral advertising other than a blanket ban on behavioural advertising? Is there anything left that the law could say other than you cannot track users for advertising purposes? Thanks.
Who would that go to? Or?
That would be primarily for Christian, I think.
Okay.
Hi, my name is Felix Mikolas from Neub. I have a question for Carolina. Basically, to what extent is the idea or the narrative that personalized advertising is very effective challenged?
Sorry, could you repeat the question?
Yeah, I can repeat the question. Is it that?
Yeah,
to what
please.
extent is the narrative that personalized advertising is very effective actually challenged, like the idea? So is there, for example, is there from the civil society groups some challenge to the idea that this works very well, or is this just like assumed to work well and will justify it on a regulatory and a technological basis here?
So let's go to Carolina first, maybe, if you may.
Yeah, I think that when it comes to the effectiveness of the ads, it shouldn't really be to civil society to prove whether it's effective. But I think also that it's difficult to, even if we wanted to produce some sort of evidence trying to change this narrative, it'd be very difficult because all that, it's not in the interest of those companies to share data about effectiveness. It's also very difficult to, I guess, to talk to advertisers about that. I'm not aware of any specific initiatives that were trying to, for instance, get some data from advertisers about how effective this is. I'm only aware of some research showing that comparing really the effects of behavioral advertising with contextual advertising coming actually from companies that have decided to take this brave step and switch off targeted behavioral advertising on the websites. And I actually do not observe any change in effectiveness, quite the opposite. Often the effectiveness changes. They, even during COVID times where there was a huge problem on the market because people were not really going out and where there were less money to spend, the advertising market suffered also a big loss of money. But even then, some organizations that have decided to switch to contextual advertising saw as well a drop in revenues, but smaller than those that relied on targeted advertising. So I don't know, maybe Catherine, maybe you have something to add on this.
I would just add that I think that actually no one in the industry knows if it works at all. Advertisers don't know if this works. The only data that they have that they use to determine effectiveness is usually given to them by the companies that sell the advertising, and they will tell you that actually they really struggle to have independent audits, for example, of the measurement data they receive from Google and Facebook in some cases. So no one in the industry knows if it works. Big advertisers who have been around for a long time and have done, they lived before internet advertising, they do TV, they do offline advertising. They're way more skeptical than smaller performance advertisers that maybe are like newer companies that have only existed in the past few years. And because they have only, this is all they know, this is the only type of advertising that they know, so they have nothing to compare it to. But I think there's a real lack of data on the industry side for anyone to really say, we absolutely need this system to work in exactly this way in order to have positive outcomes for our businesses.
Okay. So let's go to the final question, Christian. The question was, this hypothetical comprehensive ad tech law, what could it do besides from just banning behavioral advertising altogether? What could be a scenario there?
Yeah, I think it's Nicholas to ask that. It's not my job or playgrade to start announcing new initiatives.
Well, with these words, I think we can close the panel. I thank the panelists very much.